What happens when we appear for a settlement conference in court on your particular matter, and the defense now tells the judge, Judge, listen, we think Oginski's client doesn't have a case, and if they do, guess what? We only want to offer them nuisance value. What does the judge do in that instance? You want to know the answer? Come join me for this walk around the neighborhood as I tell you exactly what happens. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so let's say you sued your doctor claiming that he was careless, and now that carelessness caused you harm and injury, significant harm and injury. Well, your doctor denies all of your allegations. In fact, he says, why are you even suing me? I did nothing wrong. And even if I did something wrong, whatever I did didn't cause you harm and injury. And then he said, you know what? If I did something wrong, so did you, Mr. Patient. And then he says, listen, if I did something wrong and I caused you harm, your injuries really aren't as bad as you claim them to be. So those are the typical defenses we see in these medical malpractice cases. All right, so now your case goes all the way through the litigation process. It takes 2 years to finally get a date for trial. But before we actually go ahead and start picking a jury, the judge calls us in and says, listen, I want to go ahead and have a settlement conference. I want to see if there's any chance we can try and resolve this before you guys go out for trial. Okay, fine. So now both attorneys go into court, and during this conversation in front of the judge turns to me and asks, okay, counselor, what are you looking for in this case? What's your demand? And now I tell the judge what our demand is. Judge, our demand is $5 million. And she starts asking me what are the injuries and where's the liability. And now, after a few moments, she turns to the defense attorney and says, counselor, what do you have to offer? And now the defense attorney comes in and says, Judge, listen, we don't think we did anything wrong. We don't think that my client did anything to justify having to pay this particular injured patient. So we're not prepared to offer anything. And the judge says, you're here for a settlement conference. Either you have authority to settle or you don't. Which one is it? And now he says something. He says, you know, Judge, we might be willing to negotiate. However, we don't think this case has a value anywhere near what Oginski thinks it's worth. Really? What do you think it's worth? The judge asked the attorney. And he says, Judge, we think this case has only nuisance value. What does that mean? It means they think this highly of the value of your injuries. At least that's what they're telling the judge. That they don't believe that your injuries are worth millions of dollars. They think it's worth such a small amount that they consider it to be such a nuisance. And if they have to pay it, okay, fine, we'll pay it just because it's a nuisance just to get rid of you. Now, what do they consider to be nuisance value? Well, the answer is it depends. It depends on who's saying it, who the attorney is, which insurance company is saying it. It depends what type of case it is. It depends what the extent of your injuries are. If there really is substance to the injuries, and now your case really does have a significant value, then nuisance value might be worth a significant amount of money compared to something that doesn't have such a significant value. Again, it all depends on what is considered to be nuisance. So the judge will turn to them and say, well, what do you consider nuisance value to be? $10,000? $100,000? $1 million? The answer might be yes to each one of those questions, provided the facts support it. So what happens now during the settlement conference when there is such a huge gap between what we are demanding to try and negotiate and settle this case and what the defense might possibly have or has in their pocket but simply are not offering it because they don't want to take a position of having to offer anything at this point? I'll tell you what happens. Once the judge recognizes that there is such a wide gap between what we are looking for and what the defense thinks the case is worth, now she's going to realize, you know what? There's no chance we can resolve this case at this point. I'm simply going to set this matter down for trial. And if you guys can't resolve it on your own, guess what? Now a jury will have to make the decision. You'll both have to live with it. That's exactly what will happen. So now the judge will give us a trial date. We'll come back and we start jury selection on that trial date. So why do I share this great information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases in New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Either that or you just wanted to see the beautiful scenery behind me. Now, I realize you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8888. 8207, or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.